students, I am Tulika Banerjee. Today I bring you the next learning episode on behalf of the content writers Dr. G.S. Sodhi and Deepika Bhandari on an important unit of paper Crime in Society, that is Criminal Justice System Part 2. In this episode, we will discuss about filing of criminal charges, communal policing and policing in heterogeneous society. We would also acquaint ourselves with the correctional measures and rehabilitation of offenders, in addition with human rights and criminal justice system in India. Let us start our lecture with a look at what we are going to learn today. First is filing of criminal charges, then community policing, policing in heterogeneous society, correctional measures and rehabilitation of offenders, human rights and criminal justice system in India, and lastly the conclusion. Criminal law occupies a predominant place among the agencies of social control and is regarded as a formidable weapon that society has forged to protect itself against antisocial behavior. Criminal procedure is an inseparable part of the penal law, and the effectiveness of the latter depends much upon the proper implementation of the former. It is a right as well as a duty of every person to give information to an officer in charge of a police station about a cognizable offence. The information so given has to be registered under section 154 of the Criminal Procedure Code of 1973 at the police station and is commonly known as First Information Report or FIR. FIR is a written document prepared by the police when they receive information about the commission of a cognizable offence. It is a report of information that reaches the police first in point of time, and that is why it is called as the First Information Report. It is generally a complaint lodged with the police by the victim of a cognizable offence or by someone on his or her behalf. Anyone can report the commission of a cognizable offence either orally or in writing to the police. Even a telephonic message can be treated as an FIR. An FIR is a very important document as it sets the process of criminal justice in motion. It is only after the FIR is registered in the police station that the police take up investigation of the case. Anyone who knows about the commission of a cognizable offence can file an FIR. It is not necessary that only the victim of the crime should file an FIR. A police officer who comes to know about a cognizable offence can file an FIR himself. When information about the commission of a cognizable offence is given orally, the police must write it down. It is a right to a person giving information or making a complaint to demand that the information recorded by the police is read over to the informant. Once the information has been recorded by the police, it must be signed by the person giving the information. The informant is required to sign the report only after verifying that the information recorded by the police is as per the details given by the informant. People who cannot read or write must put their left thumb impression on the document after being satisfied that it is a correct record. Copy of the First Information Report is required to be provided by the police officer to the informant, and that too free of cost. After a First Information Report is recorded, the investigating officer would initiate detailed investigation. Every investigation by the police shall be completed without unnecessary delay and charge sheet submitted to the court. It shall be remembered that the delay in the submission of charge sheets militates against the principle of law. In cases where the accused are caught red-handed with property, there should be no delay at all in the submission of charge sheets. In such cases, the accused should be forwarded in custody to the magistrate having jurisdiction along with the charge sheet, except in cases where the accused is a stranger and his antecedents have to be verified. In offences against person including cases of murder, there should normally be no delay and difficulty in completing the investigation, and filing the charge sheet before the expiry of the remand period under section 167 of the Code of Criminal Procedure. It should be remembered that on expiry of the period of 90 days where the investigation relates to an offence punishable with death, imprisonment for life or imprisonment for a term not less than 10 years and of 60 days in any other offence, the accused person shall have to be released on bail if he be furnished bail. If there is sufficient evidence to warrant the filing of charge sheet against the accused, the investigating officer will submit to the magistrate empowered to take cognizance of the offence. The names of such of the accused as are absconding should be entered in red ink in the appropriate column of the final report form. The officer in charge of the police station shall also communicate the action taken by him to the person, if any, by whom the information relating to the commission of the offence was first given. Once the investigation is completed and a prima facie case is made out, there should be no delay in the submission of the charge sheet. The charge should be brief but at the same time clear. The date, time and place of offence should invariably be mentioned in the charge. If after the completion of an investigation, the investigating officer considers that in spite of all the steps taken, there is no prospect of obtaining any further clue and that nothing more can be done in the case, he will submit a final report treating the case as undetectable. But in instances where cases have to be referred as mistake of fact, mistake of law, civil in nature or false, the final report should be submitted forthwith. In cases where the accused person or person dies before the completion of the investigation and no person or persons can be charged, a final report should be sent with charge abated against the accused person who is dead. In this case also, all oral and documentary statements should be sent along with the final report form. Final reports should be sent to the magistrate having jurisdiction. This form will be used both for referring cases as false and for reporting them as undetectable. In the criminal justice system, police is the organization with the maximum daily contact with the public. Hence, it is important to urgently herald good governance through the much desired police reforms. Community policing means participation and support of community in policing. It can also be defined as a collaborative effort between the police and the community that identifies problems of crime and disorder and involves members of the community in the search for solutions to these problems. Community policing encompasses a variety of philosophical and practical approaches and is still evolving rapidly. Community policing strategies vary depending on the needs and responses of the communities involved. However, certain basic principles and considerations are common to all community policing efforts. The movement toward community policing has gained momentum in recent years as police and community leaders search for more effective ways to promote public safety and to enhance the quality of life in their neighborhoods. Community policing is democracy in action. It requires the active participation of local government, civic and business leaders, public and private agencies, residents, churches, schools and hospitals. All of those who share a concern for the welfare of the neighborhood should bear responsibility for safeguarding that welfare. The implementation of community policing necessitates fundamental changes in the structure and management of police organizations. Community policing differs from traditional policing in how the community is perceived and in its expanded policing goals. While crime control and prevention remain central priorities, community policing strategies use a wide variety of methods to address these goals. The police and the community become partners in addressing problems of disorder and neglect that, although perhaps not criminal, can eventually lead to serious crime. Although community policing is an old concept, it has picked momentum in India only over the last couple of decades, or so as a promising alternative to the traditional mode of policing, which is found to be reactive and often repressive, hence alienating the police further. Community policing is participative form of policing where the community, neighborhood and the police take a proactive role in involving each other to control crime and law and order management. Police has always been and remains the central agency of criminal justice system. In theory, the safety and liberty of the people depend upon the laws and the constitution, but in practice, the decisions of the legislature and the courts would remain merely on paper if there was no effective police to enforce them. The functioning of police is law in action. As a law enforcement agency, the police in all societies developing or developed has to preserve and protect the very basic need of human survival and social intercourse. And when pushed to the rock bottom, this is what the criminal justice system has been all about. Police is the foremost agency responsible for creating an ambience of peace, safety and social harmony. To achieve this goal, the police need to prevent and investigate crime, prosecute criminals and maintain law and order. Since these onerous tasks entail people's cooperation, the police cannot achieve the desired results without people's help and support. Although the law binds the people to assist the police under certain circumstances, practically it is not feasible to chase the people and compel them to fulfill their legal obligations. Moreover, an extracted and half-hearted cooperation does not fully serve the purpose. A large portion of weaker sections of Indian society normally consist of individuals whom the accident of birth deprives reasonable availability of money, power and social esteem. Social norms and customs deny them basic equality of the human tribe and culturally they stand handicapped because certain rules and facilities enjoined upon the dignity of their person are not made available to them in due course. The police needs a voluntary and wholehearted cooperation of the people to succeed in its endeavours. In the context of role of police, those sections of people who are relatively in a weaker position to defend them and depend upon others for protection of their rights, especially the right to life, liberty and dignity, may be called weaker sections. In terms of these parameters, the sections of people afflicted by poverty, ignorance, social justice and exploitation would be called the weaker sections. Women and children are the most susceptible to atrocities, more particularly in developing societies because of changing social structure and relationship. The function of the police in the case of juvenile delinquents relates to the implementation of different legal provisions concerning care and protection of the children. In other words, its role begins with identifying, tracing and locating the juvenile, taking him into safe custody, helping in rehabilitation and if so required, presenting him for the prosecution. The inception of correctional measures is believed to be the concept of preventive detention. When ordinary course of crime prevention fails and there are reasons to believe that a person is going to indulge in criminal activities and thereby put the public order in jeopardy, the police can initiate legal action to detain such persons. Many states in India have enacted their own preventive laws for detaining persons who indulge in activities prejudicial to public order. Proposals for detaining persons under the preventive laws are initiated by the police and submitted to the detaining authorities. One important component of criminal justice system is correctional institutions. Correctional subsystem seeks to rehabilitate the offender so that he or she will not violate the law again. By punishing the offender, it is hoped that other individuals will be deterred from violating the law for even the first time. There are two basic options in the correction subsystem: probation and prison. Both involves some restrictions on one's freedom. Correctional institutions play a major role in implementing human rights and thereby protect and safeguard the human rights of the citizens of a country. The correctional services, which include the prison as well as other rehabilitative institutions like probation, juvenile justice and correctional homes, can be viewed not merely as agencies to incarcerate or reform the offenders, but as an index of their efficacy of the entire criminal justice system. Prisons and allied institutions can then be regarded as a boundary subsystem because while functioning with specific objectives and operational constraints, the offender who finally goes through these institutions is either reformed or reinforced in his criminal attitude. The International Covenant on Civil and Political Rights, that is ICCPR, remains the core international treaty on the protection of the rights of prisoners. India ratified the covenant and is bound to incorporate its provisions into domestic law and state practice. The International Covenant on Economic, Social and Cultural Rights, that is ICESR, states that prisoners have a right to the highest attainable standard of physical and mental health. Prisons are not normal places. The prisoners are deprived of freedom and personal contacts with family and friends. The utility of prison as an institution for rehabilitation of offenders and preparing them for normal life has always been a controversial issue. There are quite a large number of offenders who are otherwise well behaved and are persons of respectable class of society, but they fall prey to criminality on account of momentary impulsiveness, provocation or due to situational circumstances. The real purpose of sending criminals to prison is to transform them into honest and law-abiding citizens by inculcating in them aversion for crime and criminality. But in actual practice, the prison authorities try to bring out reformation of the inmates by use of force and compulsive methods. Consequently, the change in the inmates is temporary and lasts only till they are in the prison, and as soon as they are released, they again get attracted towards criminality. It is for this reason that the modern trend is to lay down greater emphasis on the prisoners so that they can be rehabilitated to their normal life in the community. This objective can be achieved through probation and parole. The sincerity, devotion and tactfulness of the prison officials also help in the process of offenders' rehabilitation. The rehabilitation activities of the modern prison are generally of two kinds, namely psychological and psychiatric treatment, and the second one, educational or vocational training programs. The assumption of rehabilitation is that people are not permanently criminal and that it is not possible to restore a criminal to a useful life, to a life in which they contribute to themselves and to society. A goal of rehabilitation is to prevent habitual offending, also known as criminal recidivism. Rather than punishing the harm out of a criminal, rehabilitation would seek, by means of education or therapy, to bring a criminal into a more peaceful state of mind or into an attitude which would be helpful to society rather than be harmful to society. The extent to which human rights are respected and protected within the context of the criminal proceedings is an important measure of society's civilization. The criminal justice system, consisting of police, judiciary and correctional institutions, play a major role in implementing human rights and thereby protect and safeguard the human rights of the citizens of a country. Human rights are those rights which every individual has by virtue of his birth as a human being. Naturally, they are inherent, and inalienable in every walk of life in today. The individual is threatened with the possibility of violation of this human rights not only by other fellow individuals, but also by societal institutions established with the solemn purpose of safeguarding rights of all. The Human Rights Commission Act of 1993 provides for constitution of national and state human rights commissions to inquire into complaints of violations of human rights and inefficiency on the part of the government machinery in preventing violations and to suggest measures for effective implementation of guarantees provided by the Constitution and various laws of the country. Indeed, human rights have become the socio-political normative language on the new era. Human rights are those minimal rights which every individual must have by virtue of his being a member of human family, irrespective of any other consideration. The process of the criminal justice entails people's cooperation at various stages such as crime prevention, crime reporting, investigation and trial. Without active participation of the people, the criminal justice administration cannot function effectively to achieve desired results, and thus its success largely depends upon the people. The Constitution, the Indian Penal Code and the Code of Criminal Procedure prescribes certain rights and duties of the people to ensure their life, liberty and dignity, and to enable them to actively participate in the administration of criminal justice. With a view to securing justice to the people and punishing the offenders, the functionaries of the criminal justice system should strive to safeguard these rights of the people. They should also motivate the people to discharge their duties under various laws. The criminal justice system is outdated, obsolete and oppressive as it comes under heavy criticism when issues of human rights are raised at national and international forum. Policing in a democratic society is seen as upholding the dignity of the individual by safeguarding the constitutional and legal rights. Democracy gets threatened when the police cease to respect the legal and constitutional rights of the citizens and persistently disregard the due process of law. It is a known fact that a common complainant of crime is rudely received in the police station and is treated with discourtesy, indifference and indignity. Next is protection of life and personal liberty. Article 21 provides that no person shall be deprived of his life or personal liberty except according to procedure established by law. Although the right to life and personal liberty is most important, it cannot be absolute. With a view to maintaining order and securing criminal justice, the state authorities in certain circumstances have to deprive the people of their personal liberty and life by arresting or executing them in accordance with the provisions of law. The only protection the Constitution can ensure is the legal procedure which governs such arrests and executions. Next is protection against arrest and detention in certain cases. Article 22 is another important article from criminal justice point of view. It deals with the safeguards of the people against arbitrary arrest and detention. The article also contains provisions for preventive detention, which powers the police and the magistrate exercise to maintain public order in exceptional circumstances. The third are the remedies for enforcement of fundamental rights. Article 32 entitles the people to move to Supreme Court by appropriate proceedings for the enforcement of the fundamental rights. Article 32 gives the Supreme Court power to issue writs of habeas corpus, mandamus, certiorari, prohibition and quo warranto for enforcement of fundamental rights. Similarly, Article 226 empowers the high courts to issue the writs of fundamental rights and for any other purpose. These two articles secure judicial control of administrative action. By the analysis of the constitutional provisions, it is observed that the ideals of equality, liberty and dignity of the individual were kept consistently in view while framing the constitution. Various components of the present criminal justice system of India shows that most of the major criminal laws such as the Indian Penal Code of 1860, the Police Act of 1861 and the Indian Evidence Act of 1872 are still in force with some peripheral amendments. The structure of police and its working style has not changed much. However, establishment of police commissionerates in some of the states has certainly been a welcome development and has enhanced performance parameters. While recognizing rights of the people, the imperatives of security, unity and integrity of the state were also kept in view constantly. The constitution allows the state, which includes the police and magistracy, to impose reasonable restrictions on some of the fundamental rights of the people in certain circumstances to maintain order, decency, morality, etc. Thus, the constitution contains adequate provisions for fair administration of criminal justice. The problem of prison justice and rehabilitation of prisoners is only a part of the larger problem of social regeneration. The prison administration alone cannot successfully rehabilitate the prisoners. It can only make its humble efforts to set right the prisoners. But efforts will succeed only if our economics, our education and our social institutions and values are properly integrated into a coherent and harmonious whole based on the knowledge of the human institution.